I want to welcome you to the week 3 live meeting in business law. And we have to cover a lot of material this afternoon. We have 3 chapters in this week. And so I may move a little quicker than I normally do in making sure that we get all of the information in. And if you notice from the chapter heading, 2 very important issues today: privacy and how technology affects privacy. Now, we have to understand the law in our Bill of Rights has a provision that prevents the government from entering into our private life unless there is some reasonable relationship and some probable cause to do that. And as part of that privacy that we all expect, an interesting sidelight, there is no provision in our Constitution for privacy. The concept of us having our lives protected, our private lives, is developed by the Supreme Court, who decided cases involving an invasion of privacy and kind of included that in the wording of the Constitution. There's no actual amendment that covers privacy to the extent that we would expect. And the authors in Chapter 3 have given you a couple of cases here to kind of show how companies now are trying to control their employees. And I'm sure if you've worked for a large company, you know exactly what I mean as to what they are going to protect and what they want to find out about you as their employee. And the first case, Michael A. Smith versus the Pillsbury Company, sets up the situation where Mr. Smith had been having email conversations between himself and his boss. And because of these conversations, in the case, they don't give us what actually was involved with these conversations, the company terminated him. Mr. Smith, feeling that he was wrongfully discharged, sued the Pillsbury Company, claiming what I explained earlier, that this was an invasion of his privacy for the company to be monitoring his emails, and that should have been, he should have had the expectation of privacy when he was making these email conversations. The court rejected Mr. Smith's argument that there was no expectation of privacy on his part. The company had a legal right to monitor the company email, and he had no cause of action. They dismissed his case. And I think we probably would understand that this is the situation now, that most companies are monitoring the email, and so it's probably a good idea not to put anything on there that you feel would be embarrassing or something that you don't want somebody else to read. And we can just assume that your company is reading your emails. Now, the author points out on page 73 an interesting fact, that by 2003, 92% of employers were conducting some form of electronic monitoring. 92%. 26% of the companies have terminated employees for misuse of the internet. 25% for email misuse. Email seems to be a special case because 1 in 5 employers has had emails subpoenaed in recent years, and 13% have been involved in lawsuits triggered by email. So this is an important issue today. And of course, again, it's new technology that years ago, before the internet, we wouldn't even be talking about this. But it shows that as technology changes, our legal system has to keep up with it and change along with the technology. Now, the authors also have a good discussion in the chapter. I'd recommend this to you, involving the functions of privacy and really how did it develop? What are the basis for the law protecting your privacy? Another issue related to the monitoring of email is many companies today are starting to have rules regarding the lifestyle choices of their employees. And many are probably stricter than others, but this is another new area where the employer is wanting to monitor what the employee does outside of work, and that's a controversial issue. Is that really something that the employer should be involved in? Now, the case in the book is the state of New York versus guess who? Walmart. And the case is kind of interesting in how it really goes to how it ends up in a lawsuit. A married employee of Walmart who was separated from her husband started dating another employee at Walmart. Walmart discovered that these two individuals were dating, and they fired them, claiming that the two employees had violated Walmart's fraternization policy as to the interaction between employees. The interesting part of the case was that the court was having to interpret a statute that the state of New York, this is where the case was. The state of New York had a statute which said that there were certain kinds of activities that should not be prevented by employers. Certain recreational activities should not be limited by employers in the state. The court subsequently decided that dating was not part of recreational activity, that Walmart was within their rights to terminate these employees for dating each other, and the court dismissed the employees' lawsuit. So kind of an interesting result, and again showing companies trying to control the lifestyle of their employees. Now, Carriker versus Rent-A-Center takes a little different approach. Carriker involved certain management candidates, individuals who were employees of Rent-A-Center, who wanted to be managers. And as part of the requirement to be made a manager of Rent-A-Center, you had to take a series of tests. And I'm sure some involved how to manage people, some of the policies of Rent-A-Center, and situations like that. But also part of this test was a psychological test. And Rent-A-Center was doing this to determine whether these individuals had some kind of psychological problems, or they well adjusted. Well, the employees, of course, objected to this. They sued Rent-A-Center based on the fact that their privacy had been invaded and that using psychological testing was an invasion of their privacy. The court rejected this argument and dismissed their case and argued that a company has the right to do psychological testing of its employees. And so you can see how how this has been extended in recent times. Timothy versus Chase Manhattan Bank is a little different because in this case, the plaintiffs were a large group of customers who were suing Chase Manhattan Bank because they had discovered that Chase had sold some of their personal information to third-party vendors. And I'm sure you're familiar with this. The bank would give the customer's information to financial planners or someone who would contact the customers of Chase and try to solicit their business. And again, the customers based their argument in their lawsuit that this was an invasion of their privacy, that the bank had no right to sell this information to third parties. And again, the court upheld the tactic of Chase Manhattan Bank that the customer's privacy had not been violated, and therefore the rights, they had no privacy rights involving their information. And if probably since this case, you may have gotten statements from banks and other companies that you have credit with, and they will set out their requirements as to what they will and will not provide third parties, and many of them will disclose exactly what they are providing to these third parties. The last case in Chapter 3 is again an argument made by an individual that her privacy was being violated. And Ms. Lanier, I believe, was going to be hired as a librarian for the city of Woodburn. And as part of the hiring process, the city of Woodburn required a drug test for all new employees. And Ms. Lanier objected to this, that again, the argument being it violated her right to privacy, that she was being tested for drugs without any indication that she was a drug user. The court again held that the city was within its rights, that the city could test new employees for drugs, and this is pretty much the law in the United States, that companies are free to test potential employees and current employees as to their potential drug use. The last case, and it's not in the PowerPoint, I want to mention is interesting from this standpoint, and it's the Berkeley laboratory case. And what's interesting about this case was, and you can see the difference and probably why the authors included this in the text, Black employees discovered, and Berkeley Laboratories does many kinds of product development, and they have to and they want to be sure about the health of their employees. And so they were doing tests to determine, did the employees have any health problems that would hinder the work they were doing. The problem was the black employees discovered that they were being tested for sickle cell anemia that is almost always a illness that affects the black population. And they sued the laboratory, and they won based on the fact that under the Constitution, as we've talked about, the company cannot discriminate based on race. And the court held that the testing of black employees for sickle cell anemia was a violation of the constitutional protection, and the plaintiffs were able to prevail on that basis. Now, Chapter 5, of course, is another important issue involving the workplace and employees, the health and safety of employees while they're on the workplace. And the law is very concerned about employees being protected for any kind of injuries that they can suffer. Now, the first case, the Lombardi versus Whitman case, is based on the fact that after the 9/11 attacks and the collapse of the two towers of the World Trade Center, there was, of course, tremendous damage. We're all familiar with the videos of what occurred. And as part of the cleanup, employees who were doing the cleanup work were subject to contracting various illnesses that the environment there involving the building materials can result in the employees being exposed to certain harmful products. The employees had an interesting argument when they filed their suit. They claimed that the EPA, the Environmental Protection Agency, the federal agency that regulates the environment, had deliberately made statements that the environment was safer than what it actually was. And the employees were arguing, these workers were arguing, that this had harmed them because they were not able to make an honest decision as to whether they should even be working there. The court denied their lawsuit, said that the EPA's statements should not have had any effect on the workers' decision, that was a personal decision, and that by working at the trade center destruction, they were exposing themselves to dangerous chemicals, and it really was at their own risk. The second one, the Estabal, I think I'm saying that right, versus Chevron, was interesting from this standpoint. There is a federal law now called the ADA, the American Disabilities Act. And what the ADA was passed for is to prevent discrimination of handicapped individuals. And that the ADA monitors that if there are situations on the work site that could cause a disability, that the ADA would fine the owners and subject them to these fines. Where Well, Mr. Escobar wanted to work at a particular plant owned by Chevron. And the argument of the court was very interesting. The court said the ADA protects all individuals from being harmed, but the statute does not protect individuals if they accept the risk of working in a harmful environment, similar to the Lombardi case. That because he elected to work voluntarily in an area where he would be exposed to dangerous chemicals, that there was no liability on Chevron's part regarding his employment. And so again, the argument is you accept the risk of some of these high-risk jobs. Now, the Chow versus OSHA case takes a little explanation. OSHA is the Occupational and Safety Health Administration, and this is a federal law that was passed many years ago to prevent injury to workers on the job. That OSHA inspects certain work sites as to whether the work site is safe and that there's no danger that employees can be injured. And the interesting argument that was made was the owner, this Mr. Chow, had built a building with many safety violations. And it really was there were many, he had been cited repeatedly for the safety violations that he had on the property. Some of his employees were killed in a explosion of a gas line, and of course the employee sued, and the issue really came down to OSHA was enforcing some of the violations and not others. And the court held that OSHA was within its jurisdiction to use its own judgment as to which violations Mr. Chow should be penalized for. The Caskey versus Nike case is in there really for the situation. Mr. Caskey was an activist, and he had sued Nike, and the basis of his lawsuit was Nike was committing fraud in running advertising, that they complied with all employment laws within the states where their sneakers were built or being constructed. Well, it turns out, and we're all familiar with this, Nike was running sweatshops in these underdeveloped countries, and the plaintiff was alleging, well, this was false advertising, that because they were advertising that they followed the rules, weren't they committing fraud? And the court had an interesting holding. It said it was really nothing, there was no liability on Nike's part. They were merely trying to put on a good face, and that their advertising really had no effect on whether they were running these sweatshops. And so the case was dismissed, and Nike was not liable for false advertising. Now, the Madeira versus Affordable Housing Foundation has an interesting basis. Mr. Madeira was an undocumented worker. He was one of the many illegal aliens, the millions that are currently in the United States, and many of them are working. And Mr. Madeira was injured on a project of the Affordable Housing Foundation. And of course, he collected from workers' comp in the state, which workers' comp is the state-run fund that gives workers who are injured on the job benefits because of the injuries. And the defendants, Affordable Housing Foundation, had an interesting argument that they made to the court. And their argument was that because Mr. Madeira was an illegal alien, that the federal law involving immigration should preempt the state workers' comp law. And preemption means that it's the doctrine that if state law conflicts with federal law, the federal law prevails. And the court said no, that Mr. Madeira's should be able to recover under the workers' comp law, whether he was an illegal alien or not, and that he was afforded the benefits of the state workers' compensation laws. Now, Chapter 8, I'm going to condense it and really just cover these two cases. And you notice, unfortunately, Ford Motor Company is involved in both of them. And if you look at the chapter title, Risk Allocation, Products Liability, this is and you've discussed this in the discussion question, and Denny versus Ford is your written assignment for this week. And let's do a little historical background to what we're talking about here. For many years, the law was that if you were injured by a defendant, the injury was called a tort, and this area of the law was called tort law. And the case law developed that if you, as the plaintiff, were injured by the defendant, you had to prove that the defendant was negligent, and in addition to that, that his negligence was a direct cause of your injury, and that he also owed you a duty, and that he had breached that duty by, in some form, that caused your injury. Well, as the law developed, it became evident that this was a major hurdle for individuals who had been injured by a large manufacturer. And the law eventually converted to what is known as breach of warranty or strict liability. And this concept in the law of strict liability, which is also known as products liability, says that the major manufacturers, the large companies like Ford, like Walmart, like all of these major companies, they have the means to compensate people, and that the risk is being allocated is what's going on here. And so under risk allocation, if you were injured by a product manufactured by Ford, and you can prove that there was a defect in the product and that you were damaged by that defect, you recover from Ford. And Ford, you don't have to prove negligence. You don't have to go through the steps to prove that. Ford, because they're a large company and they're sending these products out, obviously an automobile is a dangerous product, and so they're liable if a defect causes the injury. Now, the Denny case involved the manufacture by Ford of a Bronco 2. And I believe the Bronco is also famous as the getaway car for the football player and the whose name eludes me at the moment, but the famous case, and of course he was escaping in his Ford Bronco. Now the court in the factual situation states that Ford knew that the Bronco was really for off-road use, that it had a high center of gravity, that it could tend to overturn, and that it should not be used as a passenger vehicle. The plaintiff, Mrs. Denny, even had testimony from one of Ford's engineers that stated that Ford was aware that the Bronco should only be sold as an off-road vehicle and not as a passenger vehicle. Well, unfortunately, the Ford marketing department ignored its own engineer's warnings and advertised the Bronco as a family vehicle, that mom could run the kids to school and to their activities, and that she and the children would be perfectly safe in the city in their Ford Bronco. Well, Ms. Denny, who had bought a Ford Bronco, was driving down the highway, and a deer ran out in front of her. And she put on the brakes, and to avoid hitting the deer, the Bronco rolled over. She and the children in the car were seriously injured, and they sued Ford based on products liability, that Ford had manufactured a defective product. And the interesting thing about the Denny case is the defect was in the design of the product, where we normally think of a defect being something breaking mechanically. And Ms. Denny was able to recover damages from Ford because the defect involved a design flaw and in the marketing of the vehicle by Ford. Now, the last case that I want to discuss, and it really is from the standpoint of an interesting concept in the law. And in tort law, the law has a concept called punitive damages. And punitive damages are awarded to a plaintiff when it's shown that the defendant's conduct was so outrageous and so without any kind of consideration to injuries that could be caused, that the court is going to punish the defendant and award a large award of punitive damages, and it can run in the millions. And the Grimshaw case is based on the Ford Pinto, which probably none of you have ever heard of, but the Ford Pinto was built in 1972, and it was part of a strategy of Ford to build an inexpensive sedan for the general public, something that would be affordable. And I'm sure we'll laugh when you hear that the Pinto cost $2,000, a complete automobile for $2,000. The problem was Ford had tried to save a little money in the design of the Pinto. And the problem was Ford had left the gas tank right next to the rear bumper. And there had even been incidents, and in Ford's testing, where if the Pinto was rear-ended by another vehicle, the gas tank exploded and would cause a fire and injuring the occupants. And guess what? Ms. Grimshaw and her son were rear-ended The car burst into flames. Ms. Grimshaw was killed in the fire, and her son was seriously disfigured. And in addition to the damages Ms. Grimshaw recovered from Ford, Ford was assessed punitive damages because the court found that their conduct was outrageous and that the injury they caused, there was no reason for them to design the car causing this kind of danger. And that concludes our week 3 meeting.